When people search for their dream home, the list of deal breakers often includes more than just the number of bedrooms or the size of the backyard. For many, it comes down to something far less tangible: freedom from unnecessary restrictions. In recent years, homeowners associations, or HOAs, have become a defining factor in where people choose to live. While some see them as a way to protect property values and maintain neighborhood order, others view them as a bureaucracy that strips away personal freedoms and enforces rules that sometimes feel arbitrary. In the case we're about to explore, that line between oversight and overreach has become a flashpoint. This is the story of a small group of homeowners who, by a twist of development history, were never legally bound to their neighborhood HOA, and how one man's personal mission to change that has set off a quiet but deeply significant conflict. The purchase that wasn't what it seemed 6 years ago. A couple purchased what they believed was the perfect home. During their first walkthrough at the open house, one detail stood out as particularly attractive. There was no HOA. For buyers wary of excessive regulations, surprise fines, or mandated aesthetic uniformity, this was a major selling point. It meant they could plant what they wanted in their yard, choose their exterior paint color without permission, and avoid paying monthly or annual fees to a governing board. The home purchase went smoothly, but months later, the truth emerged. The neighborhood did, in fact, have an HOA. The difference was that this home, along with a small number of other properties, had been built by a different developer who had pulled out before completing their portion of the community. Because of that, these homes were exempt from the HOA's authority and were never brought under its governing documents. For the homeowners, it was an unusual but welcome twist. They got the benefits of living in a maintained community without the legal obligations or dues. A divided neighborhood years passed without incident. The HOA managed the rest of the neighborhood, enforcing rules on everything from landscaping to mailbox placement. The exempt homes remained just that: separate, untouchable, and immune to the policies that their neighbors had to follow. But everything changed when the HOA transitioned from developer control to a resident-led board, working alongside a professional management company. Now, instead of a distant corporate entity enforcing rules, it was neighbors, people who saw each other in the grocery store or passed each other on walks, making the decisions. One of these neighbors, described by residents as outspoken and prone to public grievances, began openly questioning why certain homeowners were getting away with not paying dues or following the rules. The complaints spilled onto the neighborhood's Facebook page, where conversations about landscaping violations or pool access often turned into debates about fairness. The push to force inclusion, the tension escalated when this particular board member, referred to by residents simply as the old guy on the board, began calling for the HOA-exempt homes to be brought under HOA authority. His reasoning, according to public posts, was rooted in fairness. If most homeowners had to follow certain rules and pay fees, then everyone in the geographic neighborhood should be subject to the same system. What made the situation more perplexing to many was that this board member was known for frequently criticizing the HOA itself. He often described the rules as overbearing and complained about the board's decisions. Yet, in this case, he wanted to extend those same burdens to the few neighbors who were free from them. To the exempt homeowners, it felt less like a matter of fairness and more like an effort to pull others into the same frustrations, a kind of "if I have to deal with it, so should you" mentality. The legal reality. The legal backdrop to this dispute is straightforward. Unless a property is covered by the HOA's recorded governing documents, typically the covenants, conditions, and restrictions (CC and Rs), the HOA has no legal authority over that property. Changing that status would require significant legal action, often involving unanimous consent from the affected homeowners, amendments to the HOA's governing documents, and in some states, court approval. In practice, forcing inclusion is extremely difficult, especially if the exempt homeowners are unwilling. For this neighborhood, that legal barrier hasn't stopped the rhetoric, even knowing the challenge ahead. The vocal board member continues to raise the issue publicly, framing it as a matter of community unity. Why this case matters beyond one neighborhood, while it might seem like a small, localized dispute. This situation highlights broader issues in HOA-governed communities across the country. The expansion of authority. Even when the law limits their power, some HOAs or their board members may attempt to push boundaries. Testing whether they can expand their reach. Peer pressure as governance, instead of relying solely on legal channels. Some HOAs apply social pressure, using public forums or neighbor-to-neighbor interactions to push compliance. The fairness debate. At its core, this conflict raises an uncomfortable question. Should fairness be defined by everyone having the same freedoms, or by everyone sharing the same restrictions? The stakes for homeowners. For the exempt homeowners, the stakes are clear. Joining the HOA would mean financial obligations in the form of monthly or annual dues. Rule compliance, ranging from exterior paint colors to yard maintenance schedules. Loss of autonomy, requiring approval for modifications or improvements to their property. On the other side, for the HOA supporting neighbors, the stakes are largely philosophical. The idea that the community should be uniform, and that no one should be exempt from the obligations that others must meet. This is where our investigation begins. What we have is not simply a disagreement over paperwork or dues, but a case study in governance, property rights, and the limits of HOA authority. In the next section, we will break down the main conflict, examining the personalities, the legal boundaries, and the potential outcomes if this dispute escalates into formal legal action. When the HOA management company officially took over from the developer, the change was supposed to bring stability to the neighborhood. Instead, it planted the seeds of one of the strangest and most unnecessary conflicts in the community's short history. The management company introduced more formalized enforcement, clear violation notices, scheduled board meetings, and, of course, consistent collection of dues. For most homeowners, whether they liked it or not, the new structure was unavoidable. They were legally bound by their property deeds to be members of the HOA, but for a small cluster of houses, there was no such obligation. Their deeds had no recorded covenants binding them to the HOA. This wasn't a loophole or clerical error. It was a deliberate result of the development's history. The two-builder divide. Before the HOA existed, the first builder began construction on a limited section of the neighborhood. Those initial homes were sold without HOA encumbrances, meaning the homeowners had full rights to their property without an association's interference. When that builder pulled out of the project, whether due to financial issues, poor sales, or other undisclosed reasons, the land was sold to a second developer. That second developer saw value in adding an HOA. It's a common business strategy. By creating a governing body, the developer could promise community standards that might attract buyers looking for neat lawns, consistent aesthetics, and a sense of exclusivity. The problem? The developer couldn't retroactively force the original homes into the HOA. Their deeds were already recorded under a very different set of terms. That legal separation remains true today. Lest those homeowners voluntarily choose to join, they remain outside the HOA's jurisdiction. The Facebook Firestarter. For years, this arrangement caused no problems. The HOA managed its properties. The exempt houses went about their business. Occasionally, a rumor or misunderstanding would spark questions. Wait, why don't they pay dues? But nothing boiled over. That changed when one homeowner, a retired man with an outsized presence on the neighborhood's Facebook page, decided to turn the arrangement into a public issue. Let's call him Robert for the sake of the investigation. Robert is not on the board, but he's one of those figures in every community who acts like an unofficial enforcer. His posts are frequent, his tone often combative, and his grievances wide-ranging from trash pickup schedules to the height of newly planted trees. At first, Robert's posts targeted the usual suspects: HOA policies, perceived inefficiencies in management, and the occasional neighbor who left their garbage cans out too long. But sometime last year, his attention shifted. Robert began posting about the injustice of exempt homeowners. He argued that they enjoyed the neighborhood's amenities, roads, streetlights, landscaping without contributing financially. In his words, they were riding for free while the rest of us foot the bill. From venting to mobilizing, it's one thing for a neighbor to complain. It's another for them to actively push for change. Robert began encouraging other HOA members to pressure the board into finding a way to force the exempt homes into the HOA. He even suggested going to the county to see if something could be done legislatively. In one particularly pointed post, Robert wrote, "If they want to live here, they need to play by the same rules as the rest of us. No exceptions." This didn't sit well with everyone. Fact, several residents both inside and outside the HOA called him out. They reminded him that the exempt homeowners bought their properties under different terms, and that joining the HOA would mean voluntarily giving up freedoms they had paid for when purchasing the home. But Robert wasn't deterred. He reframed his campaign as a matter of equity and fairness, claiming that the exempt owners were taking advantage of shared resources without paying for them. The exempt homeowner's perspective, from the exempt homeowner's side, the entire situation feels absurd. They didn't choose to avoid HOA fees as an act of rebellion. It was a legal reality tied to their property deeds. Some even admitted they might have avoided buying the home if it had been in an HOA. One exempt homeowner told us in an interview, "We didn't ask for this setup, but we're not about to give up our property rights to make someone else feel better. We maintain our home, we keep up our yard, and we follow basic community courtesy. The difference is we don't have to get permission for every little thing, and we like it that way." For them, Robert's campaign feels less like a fairness issue and more like a classic case of misery loves company. The HOA board's position: the official HOA board hasn't taken a public stance on Robert's campaign. Legally, their hands are tied. They can unilaterally add properties to the HOA that were never subject to its covenants. But the lack of a firm public response has allowed Robert's narrative to persist on the community Facebook page. And in HOA politics, silence can often be mistaken for tacit support. Why this matters beyond one neighborhood to an outsider. This might seem like a hyper-local dispute that shouldn't matter to anyone else. But in reality, the situation touches on bigger questions about HOA power, property rights, and neighborhood politics. Can an HOA ever expand its reach? In some states, there are pathways for expansion, but they almost always require a unanimous vote from affected homeowners and a formal amendment to the HOA's governing documents. Should they be able to? This is where the ethics come in. If a homeowner bought into a property without HOA restrictions, is it fair to later impose them? What drives neighbors to push for more control? Robert's case may reveal something deeper about human nature in shared spaces. When some people feel they're carrying more burden than others, they'd rather equalize the burden than reduce it. The escalation risk, if left unchecked, conflicts like this can escalate beyond social media spats. HOA disputes have been known to spill into official complaint filings, legal threats, and even lawsuits. In extreme cases, neighbors have taken one another to small claims court over far smaller matters. Robert has already floated the idea of legal action on the Facebook page, though no formal steps have been taken. The exempt homeowners, meanwhile, have begun documenting his posts and interactions, just in case the situation turns from verbal pressure to something more serious. A brewing public relations problem? There's also the image factor. HOA disputes that turn petty or aggressive often damage a community's reputation. If word spreads that the neighborhood is embroiled in a fight over forcing people into an HOA, it could deter potential buyers and drive down property values, ironically hurting the very people Robert claims to be defending. The standoff: as of now, the situation remains at a stalemate. Robert continues to post. The exempt homeowners continue to ignore him more. In some cases, push back. The HOA board continues to avoid making a public statement. But tensions aren't easing. And in neighborhoods like this, Unresolved disputes have a way of festering until they explode, sometimes in a single heated meeting, other times in a drawn-out legal battle. Why this conflict resonates? This story isn't just about a cranky neighbor and a few exempt homes. It's a microcosm of the larger struggle over control, fairness, and autonomy in HOA-governed communities. It raises uncomfortable questions. Do we want fairness, or do we just want everyone to share our burdens? Is it ethical to pressure someone into giving up rights they deliberately kept? When does community interest cross the line into overreach? And perhaps, most importantly, once neighbors become adversaries, is there any way to go back? This is the conflict zone, a place where legal realities, personal frustrations, and human psychology collide. The situation unfolding in this neighborhood is unusual, but also deeply revealing about how homeowners associations operate, and more importantly, how they often push beyond the limits of their actual authority. At the heart of the matter is a simple fact. The handful of houses excluded from the HOA are not legally bound by its covenants, bylaws, or fee structure. That should be the end of the story. Yet here we have a board member, and perhaps other like-minded neighbors, advocating for those exempt households to be brought under HOA control, despite the absence of any contractual or legal obligation to do so. From a governance standpoint, this is where mission creep begins. HOAs are created with defined boundaries and a specific membership established in the governing documents. Those documents, typically the Declaration of Covenants, Conditions, and Restrictions (CC&Rs), are recorded with the county and attached to the property deeds of the affected homes. If a home is not included in that recorded declaration, the HOA has no jurisdiction over it. That's not a gray area. That's black and white property law. So why would an HOA, or even just individual board members, try to pull in homes that were never subject to their authority? The answer often lies in a combination of misunderstanding, ego, and a desire for uniformity. In many HOA-governed neighborhoods, there's an entrenched belief that everyone should play by the same rules, regardless of whether those rules were ever agreed upon. For some, seeing a neighbor enjoy freedoms they don't have, such as choosing their own landscaping, skipping monthly dues, or installing certain home features without approval, creates resentment. The irony here is hard to ignore. In this case, one of the loudest voices pushing for forced inclusion is reportedly a resident who openly dislikes the HOA. He complains about it, airs his grievances on the neighborhood Facebook page, and paints himself as a victim of overreach. And yet, rather than encouraging more homeowners to enjoy the same autonomy he clearly wishes he had, he's pushing for them to be drawn into the same set of restrictions and obligations he claims to resent. This speaks to a deeper psychological and social dynamic within HOA communities. Misery or frustration often seeks company. If someone feels burdened by HOA rules or dissatisfied with how the board operates, it can be easier for them to focus on leveling the playing field than on reforming the system itself. In other words, instead of advocating for fewer restrictions, they sometimes push for more people to be restricted. From a legal overreach perspective, the risks here are significant for the HOA. Attempting to assert authority over non-member households can lead to harassment claims, accusations of selective enforcement, and even potential lawsuits for interference with property rights. If an HOA board were to send violation notices or demand dues from homes not covered under its recorded CC&Rs, it would not only be unenforceable in court, but could also damage the association's credibility. There's also the question of optics. A management company and board that are perceived as trying to expand their reach beyond their legal boundaries can quickly lose trust among the membership. Even homeowners who aren't directly affected may start to question the board's priorities, especially if it appears they threw spending time and energy on matters outside their jurisdiction, rather than focusing on maintaining the neighborhood or addressing actual issues within their authority. Another important point: voluntary inclusion is a completely different matter. In some neighborhoods, non-HOA homes can opt into the association by signing a written agreement that attaches the CC&Rs to their deed. This is a binding legal process, but it's also a choice. In this case, however, there's no indication that the exempt homeowners are interested in joining, and without their consent, any attempt to force inclusion would be overstepping. The management company's role also deserves scrutiny. Professional HOA managers are typically well-versed in the scope of an association's legal authority. If a board member were to push for adding exempt homes without going through the proper channels, the management company should be the voice of reason, reminding everyone involved that such a move would require formal legal amendments, often with unanimous consent of the affected property owners and, in some states, even a recorded change in the subdivision's plat or declaration. Ultimately, what we see here is an example of how HOA overreach doesn't always come in the form of fines, liens, or foreclosure threats. Sometimes it shows up in the form of neighbor-to-neighbor pressure, fueled by resentment and a desire to impose uniformity where none is required. And while this might seem like a relatively low-stakes dispute, no one's home is being taken. No massive fines are being levied. It still underscores the importance of clearly understanding and enforcing the limits of HOA authority. Unchecked, even seemingly minor overreach attempts can set precedents. If exempt homeowners were to yield under social pressure and start following the HOA rules informally, it could pave the way for future boards to claim that those rules apply, even without legal authority. That's why the best defense against HOA overreach in any form is to firmly assert your rights early. Keep communication professional and documented, and if necessary, consult with a real estate attorney to make sure the legal boundaries remain crystal clear. From a legal standpoint, the dispute over whether non-HOA homes can be compelled to join the association is not a close call. It is an open non-shot matter of property law. In nearly every U.S. jurisdiction, the powers of a homeowners association are strictly defined by its governing documents: the Declaration of Covenants, Conditions and Restrictions, CC&Rs, the bylaws, and any recorded amendments. These documents are not merely internal guidelines. They are legally binding contracts tied to specific parcels of land through the county recorder's office. If a property is not listed in those recorded documents, the HOA has no enforceable jurisdiction over it. This legal framework exists to protect homeowners from precisely the type of boundary stretching being discussed here. Imagine if an HOA could simply decide to add new houses to its control without the owner's consent. The precedent would be dangerous. It would effectively give a private governing body the ability to impose financial obligations, design restrictions, and lifestyle rules on citizens who never agreed to them. In essence, it would be a private form of eminent domain without the constitutional protections that public eminent domain requires. The only lawful way to bring exempt homes under HOA authority is through a formal process: consent from the affected owners. The homeowners must voluntarily sign an agreement to adopt the CC&Rs for their property. Amendment to the declaration: the association's recorded CC&Rs would need to be amended to include the new parcels, following whatever amendment rules are specified, often requiring a supermajority of existing members. Recording with the county. The change must be recorded with the county, so that it becomes a matter of public record. Binding on all future owners of the property. Attempting to bypass these steps, for example, by sending violation notices to non-member homes, threatening fines, or attempting to collect dues, would likely be considered not just void, but unlawful. In some states, such conduct could expose the HOA to liability for tortious interference with property rights, defamation if false violation claims are made, or even harassment under civil statutes. From an ethical perspective, the situation is just as troubling. The foundational principle of any HOA is mutual consent, the idea that the homeowners agree to certain rules in exchange for shared benefits, like maintained common areas or community amenities. To impose those rules on neighbors who never opted in violates the spirit of voluntary governance. It crosses the line from managing a community to coercing one. It is also worth noting the hypocrisy in this specific case. One of the most vocal proponents for pulling in non-HOA homes is someone who has openly expressed disdain for the HOA. This undermines the credibility of the effort and raises questions about motivation. Is the push really about fairness, or is it about control, resentment, or settling personal scores? Ethically, HOA boards are bound by a fiduciary duty to act in the best interest of the association as a whole. This means using association resources, including time, legal counsel, and homeowner dues, for matters within the HOA's jurisdiction and for the benefit of the existing membership. Spending money or political capital trying to rope in exempt homes serves neither of those purposes. It risks wasting funds on legal dead ends and alienating neighbors, which can lower property values and foster lasting hostility in the community. Another ethical concern is transparency. If the board or certain members are pursuing this effort without openly communicating their intentions to the entire HOA membership, that's a red flag. Homeowners have a right to know how their elected representatives are spending time and resources, especially when it involves potentially controversial legal actions. Finally, the broader social and ethical implication is about precedent. HOAs across the country are already criticized for overreach, micromanagement, and overzealous enforcement of rules. Cases like this, where an association tries to extend its power to homes outside its legal reach, only reinforce public skepticism and feed into the narrative of HOAs gone wild. If these attempts go unchallenged, other boards in other neighborhoods may be emboldened to try similar tactics, further eroding trust and HOA governance. In short, the legal implications here are clear. Without explicit consent and proper legal amendments, the HOA has zero authority over non-member homes. The ethical implications are equally clear. Attempting to impose control without consent is a breach of trust, a misuse of resources, and a dangerous precedent for private governance. Dr. Evelyn Carrington, Professor of Property Law, Georgetown University. From a legal perspective, this is not a gray area. If a property is not within the recorded declaration of an HOA, the association has no jurisdiction over that property, period. These cases often stem from a misunderstanding or willful disregard of how property covenants work. An HOA is essentially a contract tied to the land. If your parcel isn't listed in that contract, no one can force you into it without your consent. The attempt to compel non-HOA homeowners to join is not only unenforceable, but it can open the HOA to liability. In states like Texas, Arizona, and Florida, there have been successful lawsuits where non-member homeowners were harassed or threatened by an HOA, and courts awarded damages. What makes this case even more remarkable is the irony. Someone who dislikes the HOA pushing to expand its reach. That usually signals that the motivation is political or personal, not legal or practical. Mark Jeffries, former HOA president and community governance consultant. When I train new boards, one of the first things I say is, stick to your lane. Your governing documents define the boundaries of your authority, both literally and figuratively. Going after homes you have no legal claim to is like a city trying to tax residents of the next county over. Even if you think you have a moral argument, you have no legal footing. Ethically, it's even worse when you consider the optics. Residents see this kind of behavior as a power grab, and it breeds mistrust. The Facebook element in this story makes it even more combustible. Airing grievances in public forums can polarize a neighborhood quickly. A smart board focuses on serving the members it already has, improving amenities, and building goodwill. Trying to draft unwilling neighbors into the HOA is a textbook way to ignite conflict that can last for years. Both experts point to the same conclusion. This push is legally unsustainable and ethically questionable. The case is not just about one unhappy resident's mission. It's a cautionary tale for HOA boards nationwide. Respecting jurisdictional boundaries isn't just a legal requirement. It's a cornerstone of maintaining a healthy, cooperative community. In the end, this case underscores one of the most fundamental truths in community living. Authority has limits, and trust depends on respecting those limits. And HOA's governing documents are not just bureaucratic paperwork. They are the legal blueprint that defines exactly who is bound by its rules and who is not. For the homeowners excluded from this HOA, the law is firmly on their side. Their properties were never brought under the association's jurisdiction, and no amount of neighborly pressure or social media campaigns can change that fact without their consent. In the eyes of the law, these homeowners are simply outside the HOA's reach, much like residents in a different municipality. But beyond the legal realities lies a deeper ethical lesson. Community harmony is built not by forcing conformity, but by fostering mutual respect. When boards or individual residents cross the line in pursuit of control, they risk eroding the very sense of community they claim to protect. This is especially true in an era where neighborhood disputes can spill instantly onto Facebook, turning minor disagreements into divisive public battles. The irony here is sharp. The person pushing hardest for these non-HOA neighbors to join is someone who openly despises the HOA's restrictions. It's a reminder that personal grievances, when mixed with positions of influence, can lead to actions that are inconsistent, illogical, and ultimately destructive. For viewers, the takeaway is clear. Know your rights, know your boundaries, and hold fast to both. If you live outside an HOA, no one can legally drag you in against your will. And if you serve on an HOA board or are active in community affairs, let this be a cautionary tale. Stick to your jurisdiction and focus on building goodwill among those you are entrusted to represent. Sometimes the best way to lead a neighborhood isn't by pulling others into your rules, but by leading by example, showing that community can thrive without coercion.